from tenants is in black and white.
If it doesn't say it in that letter, then it's not in that letter.
It doesn't say that in the letter.
Okay.
And a landlord learns there's no gray area.
It has to be in written form, just like this letter.
Well, you got me there, Judge.
You snookered him.
This is Judge Judy. Jonathan and Sarah Santibanez are suing their former landlord, Dave Schaefer, for the return of rent and their security deposit.
Judge's case number 125 on the calendar in the matter of Santibanez versus Schaefer. Parties have been sworn in. Sir, have a seat, please.
Mr. and Mrs. Santibanez, you rented a house with your family of 8 people from the defendant since 2014, so a little over 6 years. And according to your statement, in the end of July of this year, Mr. Schaefer advised you that he wanted you out of the house by October the 1st, and at all times you have been current in your rent. I think that all the parties will agree with that.
Yes.
Correct, Mr. Schaefer?
Yes.
What was the address of the house that you rented from Mr. Schaefer?
The address was 1750 in Oceanside.
Mr. Schaefer, when did you purchase
Yeah.
before they rented it? So in approximately 2012.
Yeah.
How much did you pay for it?
I think it was $470,000.
Did you ever live there?
Well, I was working on it, yeah. I do my own work, so I lived there on and off for the full 2 years.
So you bought it as a fixer-upper, and you lived there while you made it ready to use as a rental property.
Yeah, well, we
what
wanted
you're
to sell
telling
it. We wanted to sell it, but that didn't work out.
Well, after you fixed it up,
Yeah.
you tried to sell it, and that was in 2012. Is that what you're telling me?
Okay, yeah.
Couldn't sell it, so you decided to rent it.
Yes.
And they paid rent. Their rent was $3,200 a month.
I think at the beginning it was a little less.
But now, the last year or two or more, it was $3,200 a month. What was it initially?
Initially, it was, wasn't it 3,000?
Initially, it was $2,850.
$2,850.
And then it progressively went up.
Okay. But your rent when you left was $3,250.
Correct.
And you did, in fact, leave by October 1st.
Yes.
Correct?
Correct.
Do you still, Mr. Schaefer, own 1750?
Yes.
Is it currently on the market for sale?
Yes.
That is not an answer, Mr. Schaefer. Is it an escrow?
It's for sale.
Do you currently have it on the market for sale?
Yes, it is currently.
There's no MLS.
Would you?
Okay.
I'm going to.
Thank you.
What is it on the market for sale? At what price?
We
Mr.
didn't
Schaefer?
have a price. The real estate agent is here with me as a witness, and we never settled on a price. We have to do a little work on it first, and then it'll probably be around $1 million.
Who is living in the house now?
Nobody's living in it now.
Okay. They moved out on October 1st. What work have you done in the house?
Well, since then, we've tried to get the little stream running on the front. We've added a couple of closets in bedrooms so that they would actually be called bedrooms, because you have to have a closet in them to be calling a bedroom. Some patching work on one main wall in the main house, and we turned one of the little garage rooms below into another bedroom, and we had to make that.
So you've renovated the house in order to double what you paid for it.
That would double what we paid for it. Not what we had in it, but double what we paid for it, yes.
Double what you paid for it.
Yes.
And during the past 6 years or so, you've had a tenant who's faithfully paid you on average of $3,000 a month for the house. Now, this is what the situation is. You made a deal with the plaintiffs, Mr. Schaefer, and your deal with them was that if they left the house in good condition, not only would they get the realtor, who is your witness, you would return their September's rent, which was $3,250. When they moved out, you not only didn't give them their September's rent back, but you deducted money from their security deposit. So this lawsuit is about the deal that you had with them, that you would pay them sort of a bonus to get out by October 1st.
Exactly.
And this is during a COVID moratorium on evictions, you understand,
yes,
in the state of California. So you would give them a bonus if they moved out on October 1st and return their security. Your answer suggests that, well, they did a little bit of damage, so you deducted $800 for their security, and they didn't fully cooperate with the realtor.
They didn't cooperate at all, and that's what he's here to go along with.
Great. So they didn't cooperate at all.
Not at all.
So those are basically the facts. Do I get that right, sir?
Yes, in a sense.
Well, what sense is wrong?
I do have the notice to terminate the lease, where it does say nothing about cooperating with a realtor, if you'd like to see it.
I would. The letter that he sent you that you agreed to.
For the termination.
Giving you a 60-day written non-renewal notice, letting you know that I will not be renewing your month-to-month lease. I am giving you a required 60 days notice via this letter. However, in the interest of it, I will extend the 60 days to October 1st, which means that you can stay on property until October 1st, which should make a move easier for you and your family. Lastly, if the property is turned over on October 1st, which he realizes that you didn't have to do, in good and clean condition, I will refund your September's rent in addition to your deposit. Feel free to call me if you have any questions. Do you recognize that document, sir? And is that your signature? I'm checking it with the signature on your answer.
Yeah.
That's the letter that you sent to them.
I don't remember all of that.
Okay, point out any place in that letter where it says that he has to cooperate with your realtor.
If it doesn't say it in that letter, then it's not in that letter.
It doesn't say that in the letter, Mr. Schaefer.
Okay. Then it must have been in the conversation we had immediately after the letter. Immediately.
Let me explain a little bit about contract law to you, sir. You made him an offer in this letter. It's a written offer. He acted on this written offer by moving out on October 1st. So the contract is complete. The only contract is by a writing, not a conversation, not a telephone call, not a chat before, not a chat after. It has to be in written form, just like this letter.
Well, you got me there, Judge.
And quite frankly, of course, Mr. Schaefer, you know, you actually do understand that not only do you have this letter, but by your own statement, sir, it didn't matter whether he cooperated with your realtor or not, because you haven't put the house up on the market for sale. And the reason you didn't put the house up on the market for sale is because you said you were doing work on it to make it more attractive. You added a bedroom. You made closets so that you could say it's a 6-bedroom house or a 5-bedroom house or a 8-bedroom house instead of what it was in order to comply with code. So you haven't even listed it for sale. So that if you said to me, well, I listed it for sale, and we discussed that given COVID, I would give him notice and I would keep the showing short, you haven't even listed it according to you. So how you actually dare to say that your defense is that he didn't cooperate with a broker when he's been out of the house for 2 months and you haven't even listed it yet? That's what you just told me a moment ago.
He was supposed to cooperate.
Other than the fact that you snookered him. Yeah, go ahead.
Judge Judy continues in a moment.
What is this useless broker here? He has nothing else to do with his time than go and look at your property?
That's right. And he was supposed to allow the...
Then you have an idiot for a broker, and so are you.
Jonathan and Sarah Santibanez are accusing their former landlord, Dave Schaefer, of reneging on an agreement to return their rent and security deposit.
Now, you haven't even listed it according to you. So how you actually dare to say that your defense is that he didn't cooperate with a broker when he's been out of the house for 2 months and you haven't even listed it yet? That's what you just told me a moment ago. So how was he supposed to cooperate with your broker?
He was supposed to cooperate.
Other than the fact that you snookered him. Yeah, go ahead. Go ahead.
He was supposed to cooperate, fully cooperate, and I remember talking...
What? Was he supposed to? No. Schaefer.
Yeah.
What act was he supposed to do to cooperate with your broker?
He was supposed to allow the broker to look at it whenever the broker wanted to. He was supposed to allow...
What?
So the broker would see it.
For what? To look at it because he had nothing else to do but look at your house? It wasn't listed for sale and hasn't been listed for 2 months. He moved out October 1st. All of October and all of November, you haven't listed it. What is this useless broker here? He has nothing else to do with his time than go and look at your property?
That's right. And he was supposed to allow the...
Then you have an idiot for a broker, and so are you. You own $4,000 $50. Judgment for the plaintiff. We're
Okay.
done. Thank you very much.
Thank you.
This case is concluded. Parties are excused.
Well, I always heard she was going to tear me apart, and she did.
I'm very pleased with her decision. You know, we are good tenants. We paid our rent on time every month.
These very nice people did not cooperate with the broker in allowing him to go see it.
We were shocked when he would not refund what he said he would give us, which is his word in writing.
When he called quite often, 4 or 5 times, they didn't even answer his calls.
I mean, and especially during COVID-19 when you don't want people in your home.
He was supposed to let the brokers see it.
You don't want to be outside the home. You don't want to be showing the home.
He did not show them any cooperation, not only not full cooperation, not any cooperation.
I think it was a good ruling on Judge Judy's part.
All parties in the matter of Foley versus Mounier. Step to the podium, please.
21-year-old Emily Foley is suing her Mounier for failing to return her portion of a security deposit for an apartment they never moved into.
Miss Foley, you and the defendant were friends for a long time and recently decided to rent an apartment together. You located an apartment, and I was unclear, did both of you sign the lease or just the defendant?
Both of us.
And you were supposed to move into this apartment on...
September 5th was our move-in date.
Okay. In order to accommodate that, you gave the defendant $1,400, and you transferred that into her bank account. Do you have proof of that?
Yes, I do.
Would you please take it out?
This is the total that I gave her. The $300 and the $1,000 was towards the deposit on the apartment, and the $145 was $100 for a $200 holding fee and $45 for a credit check fee. And the $50 was a personal loan that...
Just a second.
Okay.
A credit check fee.
Yes, for the...
Is that what you're telling me?
Yes.
Okay. I got it. At some point, the apartment complex that you were leasing from notified you that the apartment would not be ready on the move-in date that you were given in the lease, and the apartment complex gave you you decided that you wanted to back out of the lease.
Yes.
You no longer wanted to go forward with it. And what you are suing for is the return of the money that you sent to the defendant, because the defendant seems to acknowledge that she received that money back from the apartment complex. Am I correct?
I didn't receive everything back. I did receive a portion of it.
How much did you receive back that you can prove to me?
The only thing I didn't get back was the holding fee and both credit check fees.
And I would assume that you wouldn't have gotten the credit check fee.
Yeah. They told us we
Back.
weren't going to get that back,
What was
and then
that,
we didn't get
40?
It was
Right.
$45 per
Right.
person.
Okay. So they did, in fact, return to you most of the deposit that the plaintiff gave you.
Yes.
You said you would return to her only $400 of the deposit, and your reason was that you purchased things, I assume, for the apartment.
Yes.
In contemplation of moving into the apartment together. She was the one that didn't want to go forward with it if you had to wait 2 weeks, and you got stuck with stuff that you would not have otherwise purchased. Like what?
A kitchen table, and then I did the renter's insurance.
Just a second. Where is the kitchen table and chairs?
I had to end up getting a new one because that one was too big, and I had to move. I was already...
Kitchen table and chairs.
Yes.
Was it delivered?
No, I stopped the delivery.
You stopped the delivery.
Yes, I couldn't get my money back. They said I could either keep that one or get one that was smaller.
Prove it to me.
Judge Judy continues in a moment.
You bought another one.
Yes, because that one was too big, and I was forced to keep that and keep buying stuff from them.
Okay, listen. I mean, I may be older than you are, but I know young people think they're smarter. I want you to give me a full sentence answer.
Real cases, real people. Judge Judy. 21-year-old Emily Foley is suing her former friend and roommate, 24-year-old Amber Mounier, for failing to return her portion of a security deposit for an apartment they never moved into.
You bought a kitchen table and chairs.
Yes.
Was it delivered?
No, I stopped the delivery.
You stopped the delivery.
Yes, I couldn't get my money back. They said I could either keep that one or get one that was smaller.
Prove it to me.
It says on the very bottom how you can't get your money back.
I see what this is, and I see what you signed, $450 that you paid. Did you buy another one?
I paid $100 more.
Did you buy? The question is, did you buy another?
I was forced to keep that and keep buying stuff from them because I was going to lose out on all that money.
Okay, listen. I mean, I may be older than you are, but I know young people think they're smarter. I want you to give me a full sentence answer. The answer is you took this $450, you added another $100 to it, and you bought another table that you currently own.
Yes.
Isn't that simple? Look how I said that. Without convoluted, without anything. Did you move into another apartment?
Yes, I did.
And you now have a kitchen table and chairs, right?
Yes.
That cost you $550, that you own it.
Yes.
Good. What else did you buy?
The renter's insurance.
Renter's insurance.
Yeah, we have to have renter's insurance in order to move in before we could even move in.
Fine. You ordered the renter's insurance, but before the renter's insurance went into effect, you canceled it because you never moved in.
No, we did not move in.
You never moved in. So if you never moved in, there shouldn't be any insurance. You were uncovered because you didn't own or rent the property. Are you telling me you had a loss with insurance that you're going to have to prove?
No, I didn't say that.
You didn't say what?
That I had a loss of insurance.
Well, you just told me. I said, well, what did you pay for that you didn't use?
I did pay for it.
You said
and it took
renter's
8 weeks
insurance.
to get the money back.
Trying to figure out what you spent money on. So far, it's nothing. So she's entitled to have $1,400 back, or $1,300.
First of all, I got several text messages from her mother saying that it was $1,200. She posted on Facebook $1,500, and then it was $1,691.
I just want to know how much. You just showed me what you received from her.
This is what I received. I have my bank statements. Because when it transfers, it doesn't go directly. It, takes money out of it when you transfer it to your account from Cash App.
She showed me what she sent to you. Are you disputing what she sent to you?
Yes.
What specifically are you disputing? The $1,000?
No.
Are you disputing the $300? What are you disputing?
Judge Judy continues in a moment. Closed captioning sponsored by. Want justice? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
She showed me what she sent to you. Are you disputing what she sent to you?
Yes.
What specifically are you disputing? The $1,000?
No.
Are you disputing the $300? What are you disputing?
So, Your Honor, when it gets sent through Cash App, when it gets transferred to your bank account, it takes a portion of it out. So I didn't get that full amount.
What? Just what portion?
It ended up being...
Just what portion? If it was $1,000, how much did you receive?
$990.
$990.
Yes.
Okay, that's $10. Okay. And how much of the $300 did you receive?
It was $990, and then I received $297.
Did she return $400 to you?
She returned nothing to me, Your Honor. And if I may, Cash App takes a percentage out when you choose to instantly have it. It takes 2 to 3 business days, but it's a choice to, that percentage that they take out. You can choose to have them not, and you can get the full amount that I sent her. That was her choice to have it instantly. It was not.
$1,350, judgment for the plaintiff. We're finished. Thank you very much. We're done.
This case is concluded. Parties are excused.
And on the next Judge Judy.
It was just so awful. I just couldn't take it anymore because he was cursing at me and yelling at me.
That, sir, is not a demonstration of someone who's in fear.
Judge Judy.
I believe it was the right decision. I put money towards an apartment. We didn't get the apartment. I got my money back.
I don't mind her decision. I don't owe her anything. I don't really care.
Honestly, I was glad that the apartment wasn't ready in time because her true colors came out before that.
This happened and that's fine.
A lot of lies came out, and I was, having second thoughts already.
They offered us that we could even get a different apartment, that we could move in that day. And she didn't want to do that. She wanted that specific apartment.
When the opportunity presented itself, I took it. I did what was best for me and my child.
I will always love her son. That's my godson.
She's not actually the godmother to my child. She kind of just took on that role.
I don't deal with like this.
I'm ready for better things, and I wish her peace and happiness in life.
You owe him $3,950.
No, I don't.
The virus held up her security deposit.
I missed the walkthrough because I had COVID symptoms.
Your Honor, he didn't even let us know.
It's irrelevant to this case that you had COVID.
Now, a landlord holds nothing back.
You want me to go to a walkthrough and infect somebody with COVID?
Send your mother, send your father, send a friend. You're full of baloney.
This is Judge Judy. Michelle Spaulding is suing her former landlord, Kirk Wilterding, for the return of her security deposit.
Justice case number 113 on the calendar in the matter of Spaulding versus Wilterding. Parties have been sworn in.
Miss Spaulding, your case, the defendant owes you your security deposit back. You and your family rented a house from him.
That is correct.
He gave you a 60-day notice. You did, in fact, move out, and he retained $3,950 of your security.
That is correct.
So far correct? Okay, so, Mr. Wilterding, I'm going to start with you, sir. The Spauldings rented your house. They gave you in security deposit $3,950,
Correct.
which you know you're supposed to keep segregated in a separate account. Do you know that?
I do know that, and it was
That's
segregated.
a yes? Good. And you can prove that to me if I needed it.
Sure.
Sure.
Yes.
In what bank did you keep it segregated?
I have it in a separate account that's one of my LLCs, not a personal account.
What LLC do you have there?
Just my account.
$3,950.
My account. And I actually sent them a copy because they asked for it.
Then I'm just asking you, why can't you tell me what bank you have their $3,950 in?
It's Wells Fargo.
Okay, let's proceed a little further. According to you, you had a girlfriend, you were moving to California, you lived in your house for a couple of years, then you moved with your girlfriend, then COVID struck, and you decided you wanted to move home. They were already living in the house, you gave them a 60-day notice. That's what you wrote in your answer and swore to. Do you move out? And you made a date to come with them as a result of your 60-day notice. You made a date to do a walkthrough with them before they left, which is what people do when they have a rental property so that the people are moving out, say, this is what the place looks like, and you have an opportunity to look at and say, this is my damage, and I'm going to deduct that from your security deposit. You don't have to put anything anywhere. You weren't feeling well on the day of the walkthrough. That's what you wrote, correct?
Correct.
And according to you, you lost your sense of smell because you had COVID.
What does that have to do with the walkthrough?
Well, it has to do with the walkthrough, sir, because you say by the time you entered the house and regained your sense of smell, that's what it has to do with it. You said,
I didn't say
that
any
in your
of that.
answer.
You're just making that up. I didn't say any of that.
Okay.
I missed.
Really?
If you would
Okay.
like me to explain,
Just a second.
I missed. If I can
No,
explain.
I'm just looking at it. I may, just a second. I may have been mistaken, so I'm going to read your answer. You said, due to COVID-19, I decided to move back into my house. I gave them a 60-day notice, and they complied. Michelle asked for her deposit back on the day they moved out. I told her she had to wait for damage checks, but you already had a date for a walkthrough that you did. So I missed their walkthrough. That's your sworn statement, sir. I have your signature on it.
It says nothing about smell.
Soon after that, I moved back into my house. I got COVID-19. Following my doctor's instructions, I quarantined until I felt better. It took a full month before I was symptom-free. That's what you wrote. When I finally got my sense of smell back, I knew I wasn't crazy. I can't make that up.
30 days later?
The smell of dog was obvious. The smell of dog was obvious, and I needed to change the carpet and pad. That's what you swore to in your answer, sir, right?
I missed the walkthrough because I had COVID symptoms. You can see I have a letter from my doctor, so I did not want to infect them. I didn't say that I didn't have smell.
I don't care.
And that's what...
No, just a second. You said...
30 days later.
You just said, I don't care, sir. You owe him $3,950.
No, I don't.
You missed the walkthrough.
There's more to the story. I missed the walkthrough because I was sick. I had COVID. So you want me to go to a walkthrough and infect somebody with COVID?
Send somebody in your place.
Your Honor, he didn't even let us know.
Send your girlfriend. So just a second.
I didn't have anybody available. It's a 2-hour drive. I have nobody available. I have nobody.
Send your mother.
No one.
Send
my
your
mother.
father.
My mother
Send
lives
a
in
friend.
Minnesota.
Hey, listen to me, sir. You're full of baloney because you.
I'd like to actually hear the story, and I have evidence. Why don't you let me talk?
listen to me. It's irrelevant to this case that you had COVID. It is totally irrelevant to this case.
Why do I wear a mask then? We're not supposed to infect people. We're supposed to quarantine. Really? So Judge Judy says nobody has to quarantine. No.
How many times have you had COVID?
No.
I've had it twice.
No. Shh. No. Listen to me, sir. Listen to me. Don't talk over me. I wouldn't suggest.
Well, you're not letting me talk. Why am I here?
Personally,
you're not letting me talk. Why am I here? Why am I here?
You're here to pay $3,950 judgment for the plaintiff. That's it. Out. We're done.
This case has been concluded. Parties are excused.
I'm honestly just happy that the truth came out. He clearly showed his true colors.
Because my whole house smells like dog. My brand new house, 2,800 square feet of carpet, smells like dog.
And that was my total interaction with him the entire time that we were his tenants.
They had it cleaned, they put perfume on the carpet, and it stinks.
Everything that comes out of his mouth is a lie.
So I have 2,800 square feet of dog carpet. It's $6,500 to fix. So their measly deposit doesn't even cover it.
I'm glad I'm done with this nightmare and I don't have to deal with him anymore.
All parties in the matter of Roberts versus Patton step to the podium.
Charles Roberts is suing Bryn Patton for the return.
Mr. Patton, I'm going to start with you, sir. Mr. Roberts had a non-running dirt bike, and you own a mechanic shop, and he asked you sometime last year if you could get the bike up and running.
Correct,
So far correct?
Correct.
So I want you to understand that Mr. Roberts, who I haven't spoken to yet, looks like a reasonably intelligent man. And you came out and you looked at the bike for the purposes of giving him an estimate as to how much it would cost to get this non-running dirt bike up and running. So far, am I correct?
Yes, Your Honor.
And you did, in fact, give him an estimate of what you thought, because you're the professional, of what you thought it would take to get the bike up and running. Correct?
After we went through it, Your Honor, and diagnosed everything and did a complete workup on it.
No, at the house, before you took possession of the bike, he asked you for an estimate.
Which we cannot provide.
Did you give him?
No.
Well, what did you look at the bike at his house for?
Actually, we just went to pick it up to get it going for him.
Okay, great. So you went and picked it up. On what date did you pick it up? Do you recall, Mr. Patton?
I don't recall the exact date, no, ma'am.
Do you recall the month?
April or May.
Picked up the bike.
It's unclear and it's not documented. I believe it was March or April.
Say it was March in your papers.
That's my best recollection, Your Honor.
March of 2020. Okay, so you picked up the bike, Mr. Patton, according to you, and you took it back to your shop for a diagnosis and an estimate of what it would cost to fix it. And you didn't keep that estimate to yourself because you're in business. So you relayed that estimate to Mr. Roberts. What did you tell him it would cost to fix the bike after you diagnosed it? No, I don't want to hear the word basically or like or about. Now you took the bike back to your shop.
We were given the instructions to
finishing. I'm giving you a question, sir. And what I suggest you do is a believable answer. If you don't, I assume you have family who are among the 9 or 10 million people who watch this program every day. I said to you at the beginning, Mr. Roberts is an intelligent person. If I took my bike or my car into a mechanic to be repaired, and they said I have to do a diagnostic, and they took the car to do a diagnostic, then they communicate with me as to what it will cost to fix it after they've done the diagnostic. So don't give me a lot of who shot John.
Continues in a moment.
Now, I'm not believing you.
Okay. Well, unfortunately, I'm telling you the honest truth.
Your answer belies credulity. Sir, don't look slick to me, sir. I can tell slick. Don't think of what I'm saying to you.
And later today.
I loaned her $1,000. The night that the big fight went down, that she wound up leaving my house, she gave me $500 that night before she left.
Tell me how that happened.
She went out to her car, got the $500, came and handed it to me.
Is that the way it happened?
Charles Roberts says mechanic Bryn Patton owes for the return or value of a dirt bike. Bryn is countersuing for a repair bill and storage fees.
What I'm asking you, sir, is after the diagnostic, what estimate did you give them?
We were given an order to fix the bike and get it running so that it was in proper running condition. He was leaving town.
I don't believe... Just a second.
Okay.
Now, I'm not believing you.
Okay.
Mr. Patton, I'm not believing you, sir.
Well, unfortunately, I'm telling you the honest truth.
Your answer belies credulity, sir. It belies credulity. That somebody had a non in your answer. Whatever it costs to fix it, fix it. So now, since I don't believe you, I'm going to ask you a couple of other questions, because that's what this case is about. He wants his bike back, and you have a ridiculous counterclaim. Now, is the bike currently, don't look slick to me, sir, I can tell slick. Don't think of what I'm saying to you. Is the bike currently running?
Yes, ma'am.
And is it currently in your shop?
Yes, ma'am.
Okay. Now, are you getting an appearance fee for coming to this program today?
Yes, ma'am.
How much?
To be honest, I do not recall. This is the third time this has happened, and each time things have been very different. So with the COVID, things have...
Fine. So you don't know. Whatever it is, you know it's something,
That's right.
Okay, good. So nothing better happened to this bike, because they're going to hold whatever that appearance fee is until we make this exchange and we have a running dirt bike. Do you understand?
Absolutely.
Great. Now, originally you say he came out and looked and said maybe between $300 and $400. Okay, that's a good guesstimate. You know, that never is what it is. You never get charged exactly the top end of an estimate.
Right.
What you say to me is, in your complaint, is that in July, so we had March, April, May, June, now in July, cost of the repairs had increased and would be $580. Do you recall texting him that figure, sir?
I texted many times. Oh, wait.
No.
Sorry, I apologize.
Do you recall texting him that the bill, which originally you said would be maybe between $300 and $400, is now $580 in August? Do you recall saying that to him?
Yes.
Okay. We'll take a look at that text.
Here's the text. August 21st, he says $580 plus tax.
Plus tax on parts. So say the repairs was $600.
Fair enough.
Right? Say repairs was $600, but he said, I think I have a buyer. Forget buyer, forget any other deal. $600 with the repairs then. And according to Mr. Patton's answer, Mr. Patton, I want you to listen carefully. You said I had the bike fixed within a few weeks. So that $580 plus tax on parts was a completed figure. That's what the figure was. $600, which was twice the lowest estimate that I believe that you gave him, but a couple of $100 more than the highest estimate. And according to you, you said to him, his bill, he kept making excuses. When I told him it would cost $1,500, he complained. Why would it cost $1,500?
Judge Judy continues in a moment. And later today,
we were arguing, and I was being told that I'm not thankful for anything that he does.
You were arguing. I want to know if you went out voluntarily and gave him $500 towards the $1,000 loan.
Real cases, real people. Judge Judy. Charles Roberts says mechanic Bryn Patton owes for the return or value of a dirt bike. Bryn is countersuing for a repair bill and storage fees.
Now, why would it cost $1,500?
I don't recall why that conversation. I don't know how that conversation even occurred. I don't recall it.
You don't recall telling him that the cost was $1,500 now?
Charging him $1,500? I do not recall that. No, ma'am.
Did the person who wanted to buy the bike, because I'm looking at that text message, Mr. Patton, did the person who wanted to buy the bike, was that your son?
He's correct.
Did he use it?
No.
Did he ever ride it?
Yes.
How many times? Once or more than once?
During the
once or more than...
More than once.
More than 10 times?
No. And it's just not my
Between
son.
5 and 10
we have technicians that ride it as we repair things. They have to be test-ridden.
No, I'm talking just about your son, sir, not about the technicians, just your son.
Oh, no, he only wrote it one time. The first time that he was going to write it. He wanted to see if he was going to buy it or not.
Okay, very good. All right, it's a relatively easy case, Mr. Roberts. You see, you didn't have to say anything. You have to give him $600. When you give him $600 and go and retrieve your bike, you can do that with a marshal. The bike will be in perfect running order because that's what Mr. Patton says. It's in perfect running order, and there are things that we will hold hostage in order to make sure that you get that bike in good running order for the cost of $600, which you think is fair, correct?
Thank you, Your Honor.
Very good. Very good. We're finished. That's it.
Thank you.
Thank you.
This case is concluded. Parties are excused.
Well, I think it's a fair decision. It's a little frustrating because he quoted me $300 to $400 to repair the bike.
I believe it was a fair decision. I believe we kind of came here and got the answer we wanted.
Then the bill came back as $580, and then when I went to pick it up, he presented me with an invoice for over $1,000.
There was a dispute between...
I'm just like, this is a hostage situation. I'm not going to play that game.
All parties in the matter of Swenson versus Miller. Step to the podium, please.
Doug Swenson is suing his ex-girlfriend, Kathy Miller, for an unpaid loan.
Mr. Swenson?
Yes, ma'am.
According to your complaint, sir, the defendant was your girlfriend for a couple of years.
Yes, ma'am.
From when to when?
It was March of 2017, I believe, up until September of 2020.
And it is your claim that just before the breakup, you loaned her $1,000.
Yes, ma'am.
You had a bad argument sometime in...
September 16th is when I was.
The answer says on October 18th, he showed up at my house unannounced about the money.
We could have the months.
But you broke up?
Yeah, it was in September.
In September, you broke up?
Yes, ma'am, on the 16th.
Okay. Did you go to her house to collect the money in October?
Ma'am. Yes, I did.
Okay. And you went to retrieve, according to you, the money she owed you?
Yes, ma'am. $500.
Okay.
Yes, ma'am, the $500 that she owed me. That's why I went there.
Well, when did she give you any money towards the loan?
Okay.
I thought she gave you that money when you broke up.
Judge Judy continues in a moment. Closed captioning sponsored by Judy. Have you been cheated? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
Now, you went to retrieve, according to you, the money she owed you.
Yes, ma'am. The $500 that she owed me. That's why I went there.
Well, when did she give you any money towards the loan?
Okay.
I thought she gave you that money
when
you broke up.
I loaned her $1,000. The night that the big fight went down, that she wound up leaving my house, she gave me $500 that night before she left.
She gave it to you. Look, listen to me. She gave it to you voluntarily?
Yes, ma'am. She said exactly to me,
Tell me how that happened.
Yeah. Okay, well, now here's what happened. She went out to her car, got the $500, came and handed it to me.
Is that the way it happened?
We were arguing, and I was being told that I'm not thankful for anything that he does because he came and helped me find the car. He knows about cars. So that night...
You were arguing. I want to know if you went out voluntarily and gave him $500 towards the $1,000 loan.
I did.
Did you do that?
Because he was putting it in my face.
Well, that's not what you said here in your answer, which is the only reason I'm hearing this case, because you said he blocked my car to give him the money. But that's not what you just told me.
That was the next day.
What do you mean that was the next day?
The next morning he came to my house.
I want to know when it was that you gave him the $500.
When he came to my house.
Not at his house.
No.
I don't believe either one of you. Actually, it doesn't make any difference. If you gave him the money, then you owe him the balance of $500, okay? And by giving him the $500, you acknowledge that you owed him $1,000, you gave him $500, you owe him $500. Oh, my God. Thank you very much.
Thank you.
This case is concluded. Parties are excused.
Thank you, Your Honor.
And on the next Judge Judy.
I think it was absolutely correct.
I guess it's fair.
I helped her out, and I felt she was very unappreciative.
Well, he gave me the money, and he said, don't worry about it.
We got in a huge fight. She wanted to leave my house in the middle of the night and stuff, and...
You know, don't take anything from anybody.
Yeah, I just, I wanted my money back.
Just do it on your own.
I
was in jail.
You were in jail for what?
For the assault.
There was 2 assaults.
It was a bad idea to bring back her ex.
They were telling me to get off the property.
Did you pay any rent? Ultimately, you were asked to leave.
Then he left her bloodied.
How did she cut her arm, Mr. Simple? How did she cut her arm?
Daniel pushed me.
This is Judge Judy. Cherie Zarate is suing her ex-boyfriend, Daniel Seipel, for rent and utilities, property damage, and an assault.
Judge's case number 96 on the calendar in the matter of Zarate versus Seipel. Parties have been sworn in.
Thank you. Miss Zarate, you and the defendant know each other, according to you, for well over a decade. And there was a time, according to you, that he was your boyfriend.
Yes, for sure.
When was he your boyfriend?
2007 to 2008.
Are you currently married?
No.
Who do you live with?
I live with myself, and I have a house tenant at the house that I'm at.
Is that your house?
Yes.
When did the defendant become incarcerated? In what year?
It was May of 2019 to August of 2019.
And after you were no longer involved with him romantically, did you maintain a friendship with him?
Yes.
Just friends or more than friends?
Just friends.
According to you, when the defendant's brother owned a house that another brother had lived in who recently passed away, and you and your brother, or you, made an agreement with the defendant that he could live in the house and pay either $400 a month or rehab the house because the house needed a lot of work because the house was in bad condition.
Right.
That's what she says. Just a second. And your lawsuit asks for $5,000 because you say he did not do anything in the house.
Right.
He did not do work in the house.
Right.
He did not pay rent.
Right.
And he assaulted you.
Yes.
That's what your case is about.
Yes.
Okay. Have I pretty well rounded out what your case is about?
Yes.
Yes. Now, let's deal with the assault first, sir.
Okay.
You were living in the house for a while, over a year.
Yes. Yes.
You were living in the house for over a year.
Yes.
And you paid no rent.
I was not, that wasn't the agreement.
Just a second. Just answer my questions. Did you pay any rent?
No, I wasn't asked to pay any rent.
Just a minute. There has to be a reason, sir, that you weren't asked to pay any rent. I'm asking you these questions because I have an objective. So you lived in the house for a year. Ultimately, you were asked to leave.
Yes.
And there was an altercation involving the... Yes. And the plaintiff, in addition to having the police there, filed for a protective order against you.
Yes.
And that case went before a judge.
Correct.
And you were present.
Yes. Went to court.
Did you have a trial?
Yes.
Did you testify?
Well,
he said yes or no. Did you testify?
No.
Did you consent to her having an order of protection?
I'm not aware of that. No.
Do you know whether she got an order of protection?
I was told, but I was never served. I was in jail. I was taken
you
to
were
jail,
in jail
the
for
next
what?
For the assault.
Right. Do you have a copy of the protective order?
Yes.
May I see it, please? Okay, so the proceeding was not for an assault, it was for harassment. Is that right?
It was for both.
I don't see anything about an assault there.
Okay, there was 2 assaults. The first one was on August 29th. The second one was on November 11th. And when they arrested him the second time, the police officer told me to go file for another restraining order, limiting him more.
No, just a second. The date
was August 29th.
Was on August 29th.
Right.
That's it. Do you have photographs of your injuries as a result of that?
Yes.
I'd like to see them. How did she cut her arm, Mr. Simple?
They were coming at me, her and the Beverly girl, and I pushed them in an open hand, and she fell against a stereo.
Okay. How did you cut your hand?
Daniel pushed me. after he pushed Beverly.
Okay, and what were you doing with him on that day?
Beverly and I confronted him about not paying anything since April and having his stuff all over my property. And I got a letter from code enforcement saying that they were going to fine me $500 a day if he didn't clean up the stuff from my yard. And
because he brought a whole bunch of stuff from your yard.
Yes.
Would you show me a photograph of your yard?
Oh, yes.
May I see it, please?
And there's another.
Who's mobile?
I'm sorry. That's the motorhome I stay in because the house needed to.
So you stay in the mobile home on the property?
Yes.
Well, whose bicycle is that?
All that stuff is Daniel's. Everything in the yard.
What about the lumber?
Everything.
You mean he got out of... Is that all your stuff?
That's material that I brought there to work on the house. That is my bicycle.
Well,
yes.
the lumber. I mean, he didn't get out of jail and they didn't give him lumber. They give you $1 to go on a bus. They don't give you stacks of lumber. So evidently he bought that, but he didn't use it inside the house.
Right.
You live in the trailer behind with a friend.
No,
is that right?
Myself. I lived in by myself.
You lived there by yourself?
Yes, in the motorhome, yes.
Yeah. When Daniel was in the house during that year that he was there and you were living in the motorhome, he was living in the house?
Yes.
Did you ever have dinner together?
No.
No?
Yes, we did.
Did you ever have dinner together?
Yes.
Did you ever have more than dinner?
No. Conversation? No.
Just conversation?
Conversation. I bought materials for the house to fix it up.
Yeah, well, it looks awful, and you wouldn't be living in a motorhome if you could live in the house. Okay. You pushed her, sir, and somebody, another judge, not a somebody, another person who has the same quantum of proof that I wouldn't have to if I heard this case, found that she was entitled to a protective order. And you're not allowed to put your hands on somebody. You're not allowed to do that.
I felt that I was
She has to be compensated then. Yeah. Now, do you drink?
On occasion.
Sometimes?
On occasion, sometimes, yes.
On occasion?
Yes.
More often than not?
No.
Okay. Now, how...
Year, I knew nothing about paying any rent.
When she told you to move out because you weren't doing your end of the bargain, how long did you stay in the house after
left.
she told you to move out?
I left. I was arrested the next day. When they told me to move out, that's when they came at me and I pushed them away.
That's August.
They
and then
were
you moved
telling
out.
me to get off the property.
Just a second. Just a second. They told you in August. Did you move out in August?
Yeah.
Did you move out in August? Did you ever come back?
Occasionally. I would come back and try to get some of my stuff. I had a stay-away order, so I had to take a police officer over there to get my stuff. All my stuff that I bought for the house, the materials, supplies to fix the water leak in the house, is still there.
Well, a lot of that stuff is just junk.
No, this is brand new stuff. Still
That's in the
box.
backyard. No, a lot of the stuff that she just showed me was junk. Well, the bicycles look like junk.
Okay, that's...
I don't know whose they belong to.
That was something that was brought in there before I started getting the water leak fixed in the house.
Okay.
Damages, she said, was a drywall in the house, but it had a water leak and I had to fix. I bought the material to repair that.
All right. Ms. Cerati, let me explain something to you. I don't believe that he owes you any rent. Somebody that you knew, you made a ridiculous arrangement with him, but he does owe you for this assault. Other than this cut on your arm, because I don't think he has a right to put his hands on. Did you receive any medical treatment for your injury?
No.
Okay. Who is living in the house now?
No one right now.
And you're not living in the trailer either?
No, I'm in the motorhome. I'm still in the motorhome.
You're in the motorhome?
Yes, because the house still needs fixed.
And where is your brother? Of course. Where is your brother?
My brother lives in L.A. right now, but he's coming out in a few months to live at the house.
Well, somebody better fix it up.
Yes.
Judge Judy continues in a moment. And later today...
You opened your car door. You weren't looking where you were going. Didn't even look. Didn't even look. Opened the car door. Didn't even look.
Cherie Zarate says ex-boyfriend Daniel Seipel owes for rent and utilities, property damage, and for injuries she suffered during an assault.
All right, I'm awarding you $1,500 for the injury that you sustained. He doesn't have the right to put his hands on you. Sir, where are you living now?
Where am I living? At my friend's house. My friend's house.
Do you pay rent?
No.
Good for you. Okay, we're done. Thank you very much.
All right, thank you, Your Honor.
This case is concluded. Parties are excused.
They were coming at me, telling me to get off the property.
And myself.
That wasn't the agreement. I was never supposed to pay any rent.
He was just bringing junk and dumping it in my yard.
Well, she didn't want to hear anything that I bought materials to fix the problem in the house.
I've been slowly fixing it myself.
I just got the materials to work and they said, get out.
I think he's a hoarder. He just collects things.
It was aggressive, yes.
Just harassment, and I didn't want to have to be calling the police every other day.
Not to do it again.
I'm just glad that he's finally out of my life.
And now, the next case.
All parties in the matter of Koska versus Zurati step forward.
23-year-old Brittany Koska is suing fellow motorist 22-year-old Sabrina Zurati for damage to her car caused by an accident in a university parking lot.
Oh, my goodness. That is a familiar scenario. Okay. P, that would be you. It's pulling into a spot.
Correct.
When were you pulling into the parking spot?
It was on February 14th at 7:45 a.m.
Where were you going?
Cal Poly Pomona.
To school? And you?
School. Same school.
Okay. So you're pulling into the spot, and?
As I was pulling in, I was halfway into the parking spot when she swung her door open and hit my front bumper. As I got out of the car, she got out of the car and indicated she was sorry she didn't see me. Their comment. So then I asked for her insurance information. She said she didn't find herself at fault and would like to discuss it with her father. She walked away from the scene. As I called the police, I texted her saying I called the cops.
Okay, then she came out.
Yeah.
That's what it is. And she says, Miss Sarita, you say, go ahead.
So what her statement is actually incorrect, Your Honor.
No,
my door was
just tell
already
me. I'm
open.
listening to your story.
Okay. So my door was actually already ajar. It was partially open.
Show me how ajar with your hands.
So this is my vehicle. I was about this open in my parking spot still. And she pulled, there's an empty spot next to me. She pulls in obviously in a hurry and she hits my car. She impacted it. So we get out of the car and I've never been in such a situation. So I ask, okay, what should we do? She's like, just give me your information.
Okay. I don't care about the information back and forth. So you say that your door was partially ajar. I'd like to see the damage to your car. Was there any damage to your car?
No. The door's steel. The bumper's plastic, so.
Well, if she were going fast, and what would have happened is, as you indicate,
Obviously
your
going too
door,
fast.
your door would have come off if she hit your car door.
It's kind of hard to see since the car is black, but it was fine.
Okay, into a parking space, and you're being vigilant about what's around you.
Correct.
And you see the defendant's car.
Correct.
Did you see her in the car?
I did see her in the driver's side.
If you saw her in the car, you knew she was getting either in or out, right?
Right.
So you had a 50-50 shot whether she was getting in her car or out of the car.
No, that's incorrect because since
Sure it is.
we're at school.
She couldn't have been going up or down. She had to be going in or out.
Correct.
Or sideways.
Judge Judy continues in a moment.
Were you covered at the time for liability?
I didn't realize, but it was lapsed.
So the answer is you didn't have insurance.
Correct. It was lapsed.
You think you're going to get in the last word? If you had lapsed insurance, it means you didn't have insurance.
Correct.
Don't say it was lapsed again.
Real cases, real people. Judge Judy. Brittany Koska says fellow motorist Sabrina Zurati opened her car door just as she was pulling into a parking space next to her. She is suing for the cost to fix her vehicle.
Now, what you're supposed to do is, when I'm driving and I see a passenger, I'm in a car, I'm saying to myself, are they going to get out of that car? So I'm going to slow down and be really vigilant until I pass them to see what they're doing. That's just common sense. Now, she was almost in that spot.
She actually wasn't, Your Honor.
Sure she was. She had to have been. You didn't say that that's not how the accident happened. You're not saying that that's not what...
My door was already open, Your Honor, and she pulled in.
Listen to me.
And she hit my parked car.
No. You keep saying that over and over again. What I'm telling you is that when you got out of the car, you weren't being vigilant enough.
I don't have eyes behind my head.
Oh, just a second. Well, you're supposed to. You're supposed to
She
be
was
able to
obviously
look
in a hurry,
out.
Your Honor. She was obviously in a hurry because she wouldn't have hit my car. Yeah. She didn't even want to exchange information because she was in such a hurry.
I think that you both weren't being terribly careful. Do you have insurance?
Yes, I do.
Were you covered at the time for liability?
I didn't realize, but Your Honor, it was lapsed.
So the answer is you didn't have insurance.
Correct. However, it wasn't my fault, so...
Just the answer is you didn't have insurance.
Correct. It was lapsed.
You think you're going to get in the last word? If you had lapsed, don't say it was lapsed again. You didn't have it. I didn't say you never had it. You didn't have insurance.
Correct.
Do you have insurance?
Yes.
You have liability insurance.
Yes. I don't even think she's on the insurance because her name's not on the insurance card.
Name doesn't have to be on the insurance card.
Just want to make sure.
The car has to have insurance.
Correct.
Your car had no insurance. However, I do think that you were partially responsible for this accident. I think that you were probably not vigilant enough and not careful enough. So was she, because she got out of the car, and whether she kicked the car. What kind of car do you have, by the way?
I have a Honda.
When you say my door was partially open, when you usually partially open a door, it's because you're doing something. If you're getting out of a car door,
I was reaching over to get my belongings.
Oh, just a second. Hold on a second. So you were reaching over.
My
to
door
the
was already
passenger
open.
side. You were reaching over. No, I don't believe. If she hit your car that way, it would have taken your door off.
It wasn't all the way open. She hit the edge of it.
You're sealing it for yourself. You opened the door partially to let some air in the car. You turned off the car.
It was already off. Then I opened my door.
Oh, it's getting... You don't realize where you're going.
Judge Judy continues in a moment.
I want you to go step by step with me. You turned your car off.
I reached over.
I don't want you to say my door was already open. It didn't
Okay,
open
I turned
by
my
itself.
car off.
You
I
turned
opened my door.
Slowly.
Closed captioning sponsored by. Are you the victim of a scam? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Okay, so you turned your car off. I want you to go step by step with me. You turned your car off.
Turned my car off. I took my keys out of the ignition. I reached over to get my belongings. My door was already open.
No. I don't want you to say my door was already open. It didn't open by itself.
Car off.
You turned,
opened my door.
You turned the car off.
Correct.
Step by step. You turned the car off.
Right. I set my keys down.
You set your keys down where?
On top of my purse, in my purse.
On top of your purse, which was where? On top of your purse, which was where?
On the passenger side.
Where your books were and your pocketbook, right?
Correct.
And then, slowly, you took the key out of the ignition, you put it on top of your purse, you reached over to the side to get your stuff. And
I opened my door. I set my keys down in my purse, on top of my purse. I opened my door, and then I leaned down to get my books, and that's when she impacted my car.
No, didn't happen that way at all.
Okay.
No way. He's not telling me the truth. You have an estimate to fix your car?
I do.
That's not what happened.
Either way, she hit a parked car.
No. You opened your car door. You weren't looking where you were going. Got your things, took the keys out of the ignition. I believe that. Bent down to pick up your stuff. Believe that. Didn't even look. Didn't even look. Opened the car door. Didn't even look. That's what you did. Judgment for the plaintiff in the amount of $25.65. Thank you. That's all.
Why is our excuse? You may step out.
Judge Judy continues in a moment. And on the next Judge Judy. The landlord who never left.
You slept in the laundry room next door to his apartment. That's ridiculous. You're a scammer and a fraudster.
Next, Judge Judy.
She had her sunglasses on, 7 a.m. in the morning.
Usually when it's sunny, I wear my sunglasses, so I don't know if that really causes somebody to be distracted or not. I could see if I didn't have my sunglasses on, maybe that would distract me.
She obviously was going really fast. She hit my car. Obviously, her car was damaged.
No, I was not. I'm pretty sure if I was, her door would be off.
She was going so fast, she was in a hurry. Of course,